Well, it is a very great pleasure and honour to have been asked to address you this morning at the beginning of the formal parts of the conference. I must say it's a bit cruel and unusual to be given the task of welcoming you and at this inaugural address and then being given only 10 minutes in which to speak to you. I must say that as a practitioner in the past and a judge until relatively recently, to be confined at all is something that I find difficult, and to be confined to 10 minutes is something that I think borders upon the cruel and unusual, but I will try to confine myself as best I can. This conference is a truly remarkable event, and I congratulate those who have organised it in the past and who continue to participate as you do and to support it as you have done. They are enormously important occasions, and they are important occasions where I hope that the judiciary takes part and that increasingly you will get international connection. There is, it seems to me, an ever-increasing role for an international focus in what we think of as being domestic tax. We tend to regard tax as fundamentally domestic, and that's, in a sense, an obvious thing. But I think it is best to see tax really as the domestic application of international agreements. Fundamental concepts of source and residence are fundamentally the agreements that we reach internationally and then apply domestically. And in the domestic application, we so frequently see that we are all applying the same concepts, and it is desirable that we have a deep understanding of the way in which each of our jurisdictions understand the very same concepts that we employ. And that's whether we're employing the concepts in the international agreement themselves or in the particular domestic legislation. The relationship between the Indian tax system and the Australian tax system is one that seems to be increasing. When I was a judge, I had a number of tax cases involving Indian residents in India with tax issues arising in Australia. The Oswald family was one of the ones that achieved some public notoriety in Australia and in my court in particular. Ultimately, I did not have to decide the case, fortunately, but nonetheless it was an example. Last year, our High Court had to decide a case involving one of your residents, in the case of Tech Mahindra, where the federal court, my court, although not a case in which I was involved, had been asked to decide a matter concerning the India-Australian treaty where there was an Indian decision on the treaty and nobody told the court about it. So that our court was being asked to interpret the India-Australian treaty completely in the ignorance of knowledge of what the Indian court had said about the very same treaty and the very same provisions of that treaty. That was raised on the application for special leave to appeal to our High Court, but unfortunately leave was not granted, so the issue ultimately was dropped. Just yesterday, the federal court, my court, handed down a decision in a case called Satyan Computer Services Limited, in which it decided that one of your residents was affected by the India-Australian treaty and subject to tax. The issue in that case was about whether the treaty had the effect of deeming residence in circumstances where there was no residence. And interestingly, there seem to have been about 4 or 5 decisions of your court which our revenue, the Australian Tax Office, which I gather in India sometimes our office, the Australian Tax Office, the ATO, is sometimes referred to as the Aggressive Tax Office, and possibly for understandable reasons. Anyway, our office successfully argued that the Indian decisions should be ignored, and the Federal Court just yesterday adopted that very position. I don't say that was the right thing to do or the wrong thing to do. I simply mention that as yet an example of how the relationships between the Indian and the Australian tax systems come up for increasingly important consideration. And that's what makes these conferences really so important, and why it is that the participation of you, the practitioners, and those that apply the provisions, whether it be the revenue authorities or the judges, are fully participants. There is a need for you, the practitioners, and for those who apply the law on the courts to understand that we are on a common journey where we that decide cases need to be fully informed and understand not only the concepts in tax law, but also how those tax law concepts are understood internationally. Tax law is intensely complicated. It is intensely complicated just because there is so much of it, and so much of it uses technical, complicated language, but also because the concepts that are used in tax law are difficult concepts. Even some of the simple concepts, the distinction between capital and income, can be difficult to understand and resolve. And judges are often not well equipped to understanding the complexity or even the subtlety of the simple concepts. There is therefore, I think, an important role for you, the advocates, in deepening the understanding of the judges, in providing clarity, roadmaps and explanations of a kind that we that have been required to decide cases don't always fully understand. I've been given a task to do something in a very short space of time. I hope that the short space of time has not been exceeded. I can see that Arun there is looking very uncomfortable, thinking, what is he going to say next? May I again compliment him and his co-organisers for what looks like a truly wonderful conference. I wish you all the best, and you'll hear from me again later on this morning to interrupt your lunch. Thank you.